SJC-11762, Ronald Renaud v. Commonwealth.
Mr. Collins, when you're ready.
Good morning, may it please the Court. Jeffrey Collins, Assistant Attorney General for the Commonwealth Appellant. The legislative intent of Chapter 258D, which this Court has recognized, is clear. It is to compensate individuals who are, in fact, innocent. Individuals who did not commit the crime for which they are charged. And Chapter 258D is set up by the legislature in such a way to accomplish this goal. What we have and what is at issue in this case is the eligibility provision, which is Section 1B, and in particular for this case, small Roman numeral 2, which contains the threshold requirements that a claimant must meet before being able to proceed at that threshold stage to his or her claim on the merits. And those threshold requirements have been recognized by this Court. It has been seen as, it has been termed as a screening function, which has also been recognized by this Court. A screening function whose purpose is to limit the class of claimants entitled to proceed to their claim on the merits. And in particular, as this Court recognized in the Guzman case, the screening function is designed to limit claimants to those who received judicial relief on grounds that directly implicate innocence.
What does grounds mean? Is it the theory, the legal theory on which relief was accorded to the defendant, or is it the theory plus the circumstances of his case?
Well, you know, Your Honor, if you look at the statute talks about the legal grounds which were the cause, let's say, for example, in this case, for the reversal. And so, pursuant to the statute, we look to those grounds.
So if a court reverses a conviction of, say, operating to endanger or operating under the influence of alcohol causing serious injury on the ground that, or on the theory that the Commonwealth failed to provide sufficient evidence of public way, even though the defendant was the operator of the vehicle and caused the serious injury, if the conviction is reversed because the Commonwealth failed to provide adequate evidence of a public way, and if you take another case where the court reverses on the sufficiency of the evidence because there was absolutely no evidence that the defendant had committed the crime, the result is the same in both cases.
The result is the same, Your Honor, but I suggest to you that you have to look at the specific grounds.
When you say grounds, do you look at the legal theory, the insufficiency of the evidence, or do you also have to look at what the reversing court concluded, which was in the second instance, second hypothetical, that there's absolutely no evidence of guilt?
And Your Honor, for that answer, we look to the legislative intent. And what the legislature has said is that we looked to the judicial grounds. To the grounds upon which the judicial relief rests, and whether that tends to establish innocence.
Well, what the language from Guzman is resting upon facts and circumstances probative of the proposition that the claimant did not commit the crime. So when you first started, you said it's directly establishing innocence. I don't see that language as suggesting it has to directly establish innocence as much as it's probative of the fact that he didn't commit the crime. But it seems to me it's a little looser than you are giving it credit for.
Well, you know, Your Honor, I'm quoting language from this court, from the Guzman case.
So am I.
Yes, and you know, the court has said that the screening function is designed to limit claimants to
Yes.
those who have received judicial relief on grounds that directly implicate innocence. That's the language of this court in the Guzman case. Yes, as Your Honor points out, this court has also stated that the grounds resting upon facts and circumstances probative of the proposition that the claimant did not commit the crime.
That's also Guzman.
That is true, Your Honor, right. And I suggest to you that when you apply the strict language of Chapter 250 AD, which is whether those grounds judicial relief resting upon grounds which tends to establish innocence, or the language from Guzman that Justice Botsford just quoted, Mr. Renaud is not someone who is eligible for relief under the statute. Because insufficiency of evidence, Your Honor, does not tend to establish innocence. It's simply insufficient evidence to prove guilt beyond a reasonable doubt.
Insufficient evidence because, as I read it, there is one EBT card that's cut up in 3 places and taped together. That's it. That's the one connection to this home, right?
No, Your Honor. Respectfully, the undisputed facts of the appeals court case is that there were a few things that show, and we argue, not only does it not tend to establish innocence, it establishes some evidence of guilt. And that is, yes, that Mr. Renaud's EBT card was found on the floor in the living room where the merchandise was stolen. Also, that Mr. Renaud was known to the police.
But that's using prior bad act evidence to show predisposition to commit a crime, which is not permissible.
Well, Your Honor, this was evidence that was adduced at the trial level. Mind you, this case went...
The fact that the police knew this man?
These were the undisputed facts of the case.
Knew him as what?
I'm sorry?
They just knew him?
Knew him, I'd have to go back and look at the language, but knew him in the sense of criminal activity. That
came in evidence that he's basically a bad guy?
Yeah.
That's the evidence that was
Okay, and what
was listed in
the inference is that he's a bad guy and therefore
he did
because his EBT card was found, a broken one in 3 pieces, that therefore he did it. But in any event, that's all found to be insufficient. I mean, it may not establish innocence, but it's an awful good start.
Sort of probative.
Why? I mean,
do you think the
why is it-
legislature intended to exclude this class of people? If we were to accept your rule that whenever the reason is insufficient evidence, that doesn't get you past that first step, that would sweep awfully broadly. And, you know, there are a subset of people within that insufficient evidence. The evidence is insufficient because they didn't do it. And there's no way that the Commonwealth could ever prove that they did because the evidence doesn't exist. So is it your position that the legislature intended to exclude all those people from the reach of the statute?
What the legislature intended was for the courts to interpret the statute. And the statute is clear, as this court has recognized, that there is a screening function that needs to be administered up front.
But how
No, I
fine a screen is
understand
it
that.
supposed to be?
I'm sorry?
How fine a screen is it supposed to be?
Well, the courts are
And
going
given
to...
the fact that, you know, the real burden comes later, which is a very high burden on the person who's asserting the claim. So you can have a screen that, you know, has some ability to pass through, or you can have a screen that's so fine that nobody can pass through. And what you're suggesting is one that's so fine that few could pass through.
No, Your Honor, I'm not. And as this court is well aware, it has applied the screening function. And in the Drumgold and Guzman cases, this court allowed those 2 cases to proceed beyond the eligibility stage. In the Irwin case, this court looked at wrongly admitted inculpatory evidence and made the decision that that case should not proceed. The appeals court in the Riley case, similar to the Irwin case, with the admission of evidence that should not had been admitted, performed the screening function and made the decision that that case should not
You're
proceed.
suggesting a class, an entire class, whenever there's insufficient evidence as the grounds, that is not probative of innocence, and that none of those cases should proceed.
We're here on this case, Your Honor.
Well,
we're here on the
aren't you making a broader argument than that?
I'm here on this case, Your Honor, and from the facts of this case, where there is some evidence of guilt, and I wanted, I think it was Chief Justice Gantz that asked, well, what evidence, or Justice Spina, what evidence of guilt was there for Mr. Renaud? And we had the EBT card. We had that he was known to the police. And again, these are facts that are outlined in the appeals court's decision. They're undisputed.
Well, there's going to be evidence of guilt in any case, so otherwise it wouldn't be going to trial, right?
Perhaps.
Perhaps.
Well,
Not always.
well, I mean, the appeals court saw fit to overturn the lower court's decision in this case based on what it felt was insufficient evidence to prove guilt beyond a reasonable doubt, and I think that's the key phrase
What
here.
else besides
Except the appeals court's jurisdiction to do what it did when you say
sorry,
it felt.
I didn't catch the beginning of your question.
I said, so you don't accept what the appeals court did? I mean, the judges on the appeals court didn't feel they were acting on the basis of law, were they not?
The appeals court made the decision that there was insufficient evidence for the prosecution to proceed in its case because there was not enough evidence to prove guilt beyond a reasonable doubt. That's not no evidence. Some evidence is not no evidence of guilt. Insufficient evidence is simply insufficient evidence to proceed.
But insufficient evidence may be a range from nearly proof beyond a reasonable doubt, but just short of the line, to no evidence. And you're eliminating the entire set of people, even though they may arguably prevail at stage 2, because if it turns out to be no evidence, then there's a good chance that the defendant's going to prevail.
Your Honor, again, we're here on this case.
I know, but I mean, but the argument is that the basic premise of what you're arguing is that many people who may potentially prevail at stage 2, if they were to get there, should not be allowed to get there because of the rule that you're proposing.
And, Your Honor, what we're saying here is that by its own definition, insufficient evidence is not no evidence of guilt. It's simply insufficient evidence to prove guilt beyond a reasonable doubt. That's correct.
But the court need not make a determination of the amount of evidence. The only issue with regard to whether you get a verdict of not guilty is whether the evidence is, as a matter of law, insufficient. So we don't know whether the appeals court viewed it as essentially nothing. We only knew that it failed to meet the legal standard. But you would eliminate every case where the evidence is insufficient, even if it turns out that the Commonwealth is pursuing a case, in the unusual case, where they got nothing.
Some evidence of guilt is not consistent with the legislative intent of this statute. Yes, some evidence of guilt is not what the legislature was intending.
Let me just ask you that. Let me just ask you on that point, just as an illustration. Consciousness of guilt. One of the premises or one of the tenets of consciousness of guilt is that some people act as though they were guilty when they are in fact innocent. You agree with that? That's part of the instruction, right?
Yes, sir.
So your proposition that some evidence equals no evidence, it seems to me you would have to accept from that nobody could ever prove innocent in fact, which is what's required at the second stage, if there was a scintilla of evidence from which one might infer guilt. Is that what you're saying?
Your Honor, what we're saying is that the legislature, if the legislature didn't want the courts to perform this screening function and to do the analysis at the initial stage, to see whether the grounds upon which the judicial relief rests tends to establish innocence, it wouldn't have written it into the statute. It simply would have said, as I believe the appellee will argue, is it's a pleading requirement. It's simply, notice pleading will pass through and will go immediately to a claim on the merits. But that's not what the legislature did. They intended, by the very definition of the statute, for only the title of the statute, certain erroneous felony convictions to be compensated. And in doing so, they established the eligibility provisions. This court has recognized the screening function and has allowed some cases to go through, some to not. Insufficient evidence to prove guilt beyond a reasonable doubt is not no evidence. It does not tend to establish innocence. If anything, it tends to establish guilt. And that cannot have been the intent of the legislature.
It tends to establish guilt?
Yes.
If I'm convicted of the death of John F. Kennedy, the absence of any evidence does not speak to my innocence?
This is not the absence of any evidence, Your Honor.
We don't know. This is whether we know that there is something.
Well,
okay.
what we do know is that this case, Mr. Renaud was charged. This case went through a trial. It went to a fact finder,
Right,
a
all of which the judge would tell a jury is irrelevant for the jury's consideration. It's not evidence. The fact that the defendant's charged is not evidence. The fact that they're at trial is not evidence. So far you've mentioned nothing that's evidence. The only evidence, as far as I can tell, is the EBT card and the view that the police know him as a bad guy.
Your Honor, the lower court judge, this was a bench trial, as you're aware, and that judge presumably performed his function properly and rested his decision on the evidence, and which was a conviction in this case. So to say that there was no evidence, we had a Superior Court judge that.
Okay, but the issue is not. Okay, thank you. The issue is not whether there's no evidence. I understand that the appeals court merely found it to be insufficient, which of course is all that was before them. Okay, thank you.
Thank you, Your Honor.
Chief Justice Gantz, Associate Justices, may it please the Court, Timothy St. Lawrence for Ronald Renaud. I actually think there is a logic to this case that supports Judge Conner's ruling that the basis of the reversal tended to establish innocence. And that's because no rational trier of fact, looking at the evidence against Mr. Renaud in the light most favorable to the Commonwealth, could have come away could have determined that he was guilty beyond a reasonable doubt. So if you flip that on its head or look at it conversely, every rational trier of fact that looked at the facts in the light most favorable to the Commonwealth would necessarily come away with a reasonable doubt that Mr. Renaud committed the crime.
So are you saying that just because a motion for required finding of not guilty is allowed or should have been allowed and is determined to have been, should have been allowed on appeal, the defendant is entitled to a trial under 258D?
Certainly in Mr. Renaud's case, because it's an identity case. But I would agree that yes, in most cases where, and why I qualify this is because there are other screening functions that will eliminate some insufficiency claims won't be able to pass through.
What are those?
Such as if the insufficiency is on an enhancement, a serious bodily injury or a school zone, there's obviously still the underlying felony that he's been convicted on, and so he can't pass through.
But other than those?
If you have an instance where the appeals court says the evidence that remains after, there should have been evidence suppressed, it was erroneously not suppressed for, constitutional reasons. You get rid of that evidence, then the evidence that remains is simply not sufficient. That gets through?
Well, in that case, if on appeal they suppress the evidence, I don't think at that point they'd be able to then go on and say,
Yes,
rest
they
of the
would.
evidence is
No,
insufficient.
yes, they would. They could say.
They do all the time.
Sure, and say, you send it back to reverse.
Send it
no
back.
no new trial because there's insufficient evidence without the thing, the quantum that should have been suppressed. There is insufficient evidence as a matter of law to go forward.
Okay, I stand corrected. I apologize. In that case, I think the judicial decision obviously would talk about the motion to suppress and that evidence. So in that case, you would look at that decision and say, okay, it was reversed on insufficiency grounds. However, we know from the opinion that there was strong evidence of guilt if it was a drug case, a search warrant case or something. And
the statute allows that.
The decision had nothing to do with guilt or innocence. It really had to do with the legality of the admission of certain evidence, and once that evidence is no longer admissible, there is no other evidence.
right, so in that case, I would have to agree that would not pass through.
Because under the wrongful conviction statute, if you get to the trial stage, that evidence, in this instance, that comes in, that's right. Yeah.
Right. But other cases, for instance, a case this court decided just, I think this year, I think it was Justice Spina's case, the Simpkins case. You reversed a couple of his convictions on insufficient evidence. However, you affirmed other convictions, so he wouldn't be able to pass through, for instance. And there's a lot of cases where another case is an attempt case you decided where it was insufficient evidence of attempt. However, the other charge of enticement of a child was affirmed. He can't pass through. For instance, a possession with intent to distribute heroin, insufficient evidence on the intent to distribute, still guilty of the lesser included felony of possession of heroin, can't pass through. So I think it's going to be a small subset of the already small subset, I would suggest, of cases that get flipped on insufficiency of evidence that are going to be able to pass through. But
Isn't it safer, well, more prudential, I guess is the better word. I think the Innocence Project says you should have a blanket rule that anything insufficient should be automatically gets to stage 2. I mean, a reversal based on a directed verdict, or it should have been a directed verdict, judge gets to stage 2. And it seems to me that it is probably more prudent to actually look. I mean, wouldn't it be more proper to look at every facts and circumstances on a case-by-case basis? I mean, your case may be one thing, but just the illustrations that you've made.
right, and I would agree. I think you have to look at it on a case-by-case basis because, for instance, just because of what you're talking about with suppression of evidence, that should not pass through if the evidence that was suppressed was a
confession.
Substantial, exactly. That wouldn't then necessarily tend to prove innocence. I do think, though, that tend to prove innocence should be considered a low standard, and I think that's how this court has looked at it. Tends to establish any tendency. This court has used that language, and so I think it would actually, if the court were to decide otherwise against Mr. Renaud in this case, I think it would kind of create an anomaly in the law where I would suggest claimants like Drumgold and Guzman, who, even with the new exculpatory evidence, they still could have been found guilty beyond a reasonable doubt at trial if it had proceeded that way. They would be eligible, but somebody that could not have been found guilty would not be eligible. So I think it'd be an inconsistency in the jurisprudence. But
at bottom, that really has to do with the conclusion or the determination that they're innocent. So the reason what you're proposing isn't, I think what you're proposing is, as long as the insufficiency doesn't go to a police misconduct kind of policy, we don't want to allow this in because of the way you got that contraband in the trunk, right? But it's contraband in the trunk for which you otherwise would have been convicted for trafficking. That you wouldn't say that's not the kind of sufficiency case, I gather.
That's the only, well, in addition to the ones where there's, felonies that are still affirmed or there's
Well, yeah,
lesser
apart from
included.
those,
Put those aside because they're ineligible for
They're
kind of
ineligible anyway.
on a different ground. But that case where there's a suppression of significant evidence, that would be the case where you have to, I would suggest, dig into the facts and decide based on what the evidence was that was suppressed.
Statute refers to on grounds which tend to establish the innocence of the individual. So if the primary ground of the case is the suppression of evidence, that may distinguish it from a case in which the only ground is the insufficiency of the evidence.
That's right. I think that's right, Justice Gantz. The ground would be the suppression of the evidence. That's why the case was reversed. And then in dicta or as a result of that ground, there was insufficient evidence. So, yeah, I would agree with that. And just a last point about if you were decided against Mr. Renaud in this case, I really don't see how, other than the omission of exculpatory evidence at a trial, what other type of claims could be brought under the statute. And if that's the case, I think the legislature would have simply said, wouldn't have used the grounds which tend to establish innocence, would have said the omission of exculpatory evidence, reversal on the basis of the omission of exculpatory evidence. So,
Can I ask you a minor question?
Sure.
It came up, and I wasn't sure I could tell from the appeals court reciting the facts didn't say that there was prior criminal conduct, just said they knew him, right? What was before the...
Right, and my recollection of the transcript was that the testimony was simply that we knew him, and therefore we were able to call him up.
There was no bad acts type of evidence?
No, it wasn't allowed that we knew him from, him running around doing criminal.
What was the other evidence Mr. Collins mentioned?
Guilt,
there was the EBT card, there was the knowing. Was there anything else?
Yeah, consciousness of guilt was claimed, right?
It was claimed. They put in...
Pick it up.
They put in evidence that they called him, said we have it.
Right.
Come pick it up.
Come get it if,
He
and
testified,
he didn't.
too.
He testified at trial.
That he hadn't seen it.
He hadn't seen it and that it was useless to him because he had discarded it in his boarding house. It was broken.
But that doesn't get weighed in the...
Right. That wasn't part of the
But consciousness of guilt
insufficiency.
was.
What's that?
The argument, there was an argument of consciousness of guilt.
There was, but the appeals court plainly
They rejected.
rejected it and said that really wasn't
Right.
probative evidence.
All right.
Thank you.
And we'll take our morning break.